here in response to the Dobbs decision, and of course there are many of us who believe that no response is necessary. The fetal heartbeat bill is the law of South Carolina, and it should be given a chance to work, and then we could respond. But be that as it may, the presenters that we bring to you this morning, I hope will shed some light on why many of us believe that South Carolinians are empowered in connection with consultation with their health care providers and their families to make medical decisions that they believe are in their own best interest. And what we surely don't want is to put the physicians of this state in a position where they've got to choose between following the law and committing malpractice. And so as we carefully weigh the bills that may come before us, we've tried to, or going to try to bring you different perspectives. And our first speaker, and I'll remind all the speakers in this little part, you got about 5 to 7 minutes, so be on task. First is an attorney, Susan Dunn.
Thank you for the opportunity to speak. I'm an attorney in private practice in South Carolina. I've not been hired by anybody to come and say anything to you. I'm coming as an attorney who cares very much about the state, as an attorney who wants doctors to want to practice here, as a citizen of South Carolina who wants families to be here to raise their chosen families. I was asked to come because I've practiced law in the courts of South Carolina, raising constitutional issues for well over 40 years now. And I came prepared primarily to be available to all of you to answer any question that you might have. But since now I find out when I got here that I'm also going to make a presentation, I can't help but respond personally, not as a lawyer, but as a woman in South Carolina, to Dr. Jackson's presentation. That picture of the ectopic pregnancy broke my heart. I had an ectopic pregnancy. You can look at that picture by itself and not realize that behind that picture was a mother bleeding to death. That an ectopic pregnancy will kill the mother. My ectopic pregnancy would kill me. My daughter would not have had a mother. My son would never have been born. Had that romanticized version of a fetus compromised my medical care? I can't help but say that because I couldn't look at that picture without knowing the full ramifications of glorifying that picture. But you didn't really ask me here about my personal story. I do want to give some background in terms of where we are legally in connection with the issue of abortion in South Carolina. One is that you are government. You are not a religious institution. I listened to much of the argument that you heard before, and people are making religious arguments. Religious arguments are extremely important, but they're not the job of the government. The government is to create a context in where its citizens can function as effectively and freely as possible, carrying on the responsibilities that we've given to them. And by and large, within our legal system, the responsibility for children lands on their parents. Once they're born, and all the way up until they're 18, the decisions about their life and what happens in their life belong primarily to the parents. We hold the parents responsible, and they're the ones who've got to take care of everything, and we let them make life and death decisions about their children because someone needs to. It's hard. Some parents will make the wrong decision, but the government has given that responsibility primarily to the family. And so we're in the context of that. Within the context of, generally speaking, citizenship has begun at birth. You know, your Social Security is calculated by when you were born. You're given a name when you're born. You can be baptized after you're born. All of those things happen after birth. And generally speaking, birth has been the moment in which a new human being is recognized. Now, that's not to say that there isn't a whole lot that goes on between fertilization and birth, but in terms of the government's coming in has been primarily at birth. Now, South Carolina is particularly specific there because we have a South Carolina case that actually says that a third trimester fetus can be considered a child for purposes of child protection. So we have a really specific case that decided that. The implication of that case is that prior to the third trimester, there is no child. That doesn't mean there isn't potential life. That doesn't mean that that isn't something significant, but it does limit the government's involvement, and that's what you're interested in, is where does the government's responsibility start and where does it stop? I would echo what Senator Hutto said, in that South Carolina already has an abortion statute on the books that is in effect, that is being tested in court. It's being tested in state court, and it's being tested in state court exactly the way that Dobbs asked for it to be. Let the state decide. The state of South Carolina, in its wisdom, put a specific right to privacy in our state constitution in the 1970s. It's that right to privacy that is being defined in the courts, the South Carolina courts right now. And it makes a whole lot of sense for this august body to wait and find out what that decision is going to be before we create a whole bevy of more lawsuits. And believe me, there are plenty of lawyers in South Carolina who can make all kinds of lawsuits if you go in the direction that it appears that we're going in terms of extending the legislation that is connected with abortion. The right to privacy seems kind of vague, but I can stand before you as a woman and let you know that my uterus is about the most private thing I have. If you can't search my house for criminal behavior without my consent or a specific warrant, how do you get to search my uterus to find out that I'm pregnant even before I know I am? Because you're saying that if life begins at fertilization, then my uterus no longer belongs to me, it belongs to you. And I don't think the government wants that responsibility. There's a case out of South Carolina, Ferguson versus the city of Charleston, which addresses some of the issues and basically says that you can't take medical information and use it for criminal purposes without a search warrant or a consent. And some of the things that have been discussed today would be very much impossible if you're not taking private information and giving it to the government because the government has decided it needs it because it's going to be responsible from the time of fertilization. And while we're not talking a specific bill, I do know bills have been proposed that seem to limit the ability to talk about abortion, the ability to say, for instance, that abortion is not legal in South Carolina, but it is legal in New York, and to criminalize that sort of speech. That's clearly going to raise pretty significant First Amendment issues, and I would call Bigelow versus Virginia to this body's attention so that, before you wade into that, consider the decisions that have already been made. And there are also issues that deal with the traveling between states, perhaps for the purpose of obtaining an abortion. But it also raises issues, as we talk about it today, is that if a couple from New York has the good sense to vacation and honeymoon in Hilton Head, and a baby is conceived in Hilton Head, does that baby belong to South Carolina? Does that baby belong to New York? Or does that baby belong to the parents? Thank you. And I'm available for questions, I guess, at the end.
At the end.
Thank you.
Thank you.